Good evening, friends. Welcome to this Nani Palkiwala Wednesday Law Club's special show. This is specially arranged for AOR examination leading cases. We already covered 32 cases in session 1 and session 2. And today in session 3, we will cover more 16 cases and another balance 16 cases we will cover in session 4. So let's see. Case number 33, Pramati Education and Culture Trust and others versus Union of India. This case was decided on May 6, 2014. Judges is 5 judges chamber. The cases depend upon Article 14, subsection 5, sub-article 5 by 1993rd amendment is valid. Specifically, this amendment is done for the right of education, right to education in aided and unaided schools. This is a special outcome of this leading case. A Constitution of India, Article 14, 5, as inserted by Constitution 93rd Amendment Act 2005 and Article 14, 19(1) G and 21. Constitutional validity of Article 15(5). It is held in this case. Article 15(5) does not alter the basic structure and framework of the Constitution. The provision is also not violative of the concept of the secularism. None of the right under Article 14, 19(1) G and 21 have been abrogated by Clause 5 of Article 15 and hence it is constitutionally valid. दोस्तों, ये एक जजमेंट के कारण अच्छे इंग्लिश मीडियम स्कूल में भी कुछ सीटें फिर पुअर लोगों के लिए, इकोनॉमिकली जो वीक हैं उनके लिए रहने लगी. दिस इज वेरी ग्रेट अचीवमेंट दिस जजमेंट हैव डन. आर्टिकल 21A as inserted in Constitution 86th Amendment Act 2002, 19(1) G and 31. Constitutional validity of Article 21A. There is nothing in Article 21A which conflicts with either the right of the private unaided school under the Article 19(1) G and the right of minority schools under Article 31. Case number 34, Messrs. Kailash Nath Associates versus Delhi Development Authority and others. This case was decided on January 9, 2015. So I'm reading this summary from this AOR examination leading cases book. This is authored by me, Jayprakash Somani, and this is this is short book which is easily anybody can handle, and yeah. But this is not alternative to original judgments. Original judgment is always original judgment. लेकिन स्टडी करने के लिए फॉर शॉर्ट के लिए अच्छा रहेगा, और 11th आवर प्रैक्टिस के लिए भी. While you are going at the time of examination before 2 hours, 3 hours, only read 1-2 paragraph of each case, even though you can remember that case, that summary of that case easily. And this book is available on Amazon, Flipkart, national, international Amazon, UK, international Amazon, USA, everywhere you can find this book. You just type on Amazon or Flipkart or that Notion place, Jayprakash Somani books, you will get all my books. All my books are related to Supreme Court case laws. This is the specialization. Because we are handling different matter in Supreme Court, so we have to study different cases differently. So these are the compilation of the judgments, short summary, leading case note, like that, decided, held, ratio descendings, everything is covered. So, friend, in this case, this case, 34 number case is depend upon the Contract Act. I'm again reading the cost title of this case, Mrs. Kailash Nath Associate versus Delhi Development Authority and others, January 9, 2015, decision date. Contract Act के ऊपर ये है. Contract Act is very important act in Corporate Act. ध्यान में रखिए दोस्तों. In Corporate Act, Contract Act is the major. Every agreement, every treaty, every depend upon the Contract Act. And when it get infringed, it will get the misconduct from either any party to fulfill that contract. That time, then arbitration, legal matter are proceeding. So here, public auction is there, and earnest money. This case is on earnest money. Let the exactly what is this case, what are the findings of the apex court, our judges. This is the two-judge bench. Contract Act 1872, public auction, earnest money, forfeiture, appellant highest bidder for plot deposited 25% of the bid amount, earnest money rupees 78 lakhs with ODA. Balance 75% was to be deposited within 3 months. Extension of time for payment by DOA twice. Thereafter, several letters written by the appellant to DOA, but no response. Subsequently, letter written to ODA to the appellant that his case was referred to Union of India for its approval for condoning the delay. Condoning the delay. Case being one of the New Zealand, which was later declared by the central government as non-New Zealand. On DDA's request, appellant consented to making payment of the balance amount with interest charge. After few years cancellation of allotment of the plot by ODA and consequent forfeiture of the earnest money, suit for specific performance and damages and recovery of the earnest amount by the appellant. Subsequently, DOA re-auctioned the premises fetching rupees 11.78 crores. Dismissal of suit by the single judge of the High Court, but order refund of the earnest money forfeited with 9% interest per annum. However, division bench upheld forfeiture of the earnest money. On appeal, single way earnest money, which earnest money already that company have paid, but due to delay, sometime balance amount they cannot pay. So they ODA makes announce different option, yeah. But earlier payment, balance payment is on. Single bench give the judgment in favor, give earnest money back with interest of 9%. But double bench of High Court, reverted that, and the double bench upheld forfeiture of the earnest money. Earnest money forfeit, it should be forfeited. On appeal, फिर हमारे apex court में, when this case comes, so apex court decided it was arbitrary for the DOA to forfeit the earnest money. In the absence of notice to deposit the balance 75% amount within a certain started time, there is no breach of contract on the part of the appellant, and consequently, earnest money could not be forfeited. So, this is the 34th case. Now, leading case number 35, Shreya Singhal versus Union of India. This case was decided on March 24, 2015. This is depend upon Information Technology Act 2000. Section 66A. and it is declared, Section 66A of Information Technology Act declared unconstitutional. You can find my one video on Information Technology Act. You can find my one video on Contract Act also, and one Nani Palkiwala bigger show for lawyers on Contract Act with some case laws of Supreme Court. You can find on in my YouTube channel. There is separate playgroups. You can get it. My small videos are the for general public for understanding of that law. It may be useful for the lawyers also, no doubt. But my Nani Palkiwala show is specifically for lawyers, law students, for corporates, and for educated people who wish to understand that law properly. This is not general for common people. Friends, what is in this case? Information Technology Act 2000, Section 66A, constitutional validity held. It is held by Supreme Court. Section 66A is a violation of Article 19(1)(a) and is not saved under Article 19(2). It arbitrarily, excessively, and disproportionately invades the right of free speech and upsets the balance between such rights and reasonable restrictions imposed thereupon. The expression used in Section 66A are upon ended, vague, and undefined. The reach of this section is such that it has a chilling effect on the free speech and thus suffered from the vice of overbreadth. Therefore, Section 66A as a whole is declared unconstitutional. Constitution of India, Article 19(1)(a) and 19(2). Doctrine of pith and substance also discussed here. Doctrine of severability is also discussed in this case. Reasonable instructions, and one more paragraph I want to read from this case is that when it comes to democracy, like liberty of thought and expression is a cardinal value that is of paramount significance under the constitutional scheme. There are three concepts. I'm not telling, this is narrated by judges. There are three concepts which are fundamental in understanding the reach of this most basic human right, that is the freedom of speech and expression. The first is discussion. The first is a discussion. Second is advocacy, and the third is enseignement. So after deciding this case, उसके पहले ये केस के ऊपर एफआईआर होती थी, पुलिस अरेस्ट करते थे, लेकिन ये केस डिसाइड होने के बाद फिर अरेस्ट होना बंद हो गया, तो भी पुलिस अरेस्ट करती थी. फिर सुप्रीम कोर्ट रिट्रेटेड अगेन इन अनदर जजमेंट कि नाउ स्टॉप द अरेस्ट अंडर दिस सेक्शन वगैरह वगैरह. तो ये बहुत इंटरेस्टिंग केस है. और ये 66 सेक्शन 66A इनवैलिड कैसा है, अनकॉन्स्टिट्यूशनल कैसा है, ये अगर डिटेल में और पढ़ना है तो यू हैव टू रीड द जजमेंट. दोस्तों, ये AOR के एग्जामिनेशन के लिए आपको पढ़ने का समय नहीं मिला है पूरा जजमेंट को, नो इशू, नो डाउट. बट आफ्टर एग्जामिनेशन don't forget to read these 64 leading cases. Now, case number 36. Supreme Court Advocate on Record Association and another versus Union of India. This case was decided on 16th October 2015. 99th Amendment Act, National Judicial Appointment Commission, NJAC, unconstitutional declared this act. 5 judges benches, that is constitutional bench, declare this act is unconstitutional. I will not give any my opinion upon this particular case, because nowadays there is law ministry and Supreme Court judges, there is a little bit fight that. So whether a collegium system is good or already collegium system is there properly. This act was unconstitutional declared by Supreme Court, but legislation is considering the Supreme Court is encroaching, that is judiciary is encroaching the power of legislature, like that some discussions are there. So it is not good to give my personal opinion upon this case on public platform. So friends, I am reading the some related paragraph from my book. See, Constitution 99th Amendment Act 2014, Collegium System of Appointment of Judges to the Supreme Court and Chief Justice and Judge of High Courts, and transfer of Chief Justices and Judge of High Courts from one High Court to another High Court. New scheme contemplated for replacing the collegium system. 6 members National Judicial Appointment NJAC. इसके ऊपर आपको सवाल आराम से आ सकता है कि इसमें ये जो how many members will be there in as if NJAC Act is as per NJAC Act, how many members are there and what are the qualifications, like that. Then you can read that from your head notes properly and you can write it. Use head note, or you can without head note also. If you remember, you can read it. So I'm reading that 6 members National Judicial Appointment Commission set up under the age of Constitutional 99th Amendment Act 2014, reach with the National Judicial Commission Act 2014 NJAC, composed of A, the Chief Justice of India, Chairperson ex officio disposition. B, 2 other senior judges of Supreme Court next to Chief Justice of India as a member. This is also ex officio. So 3 members from Supreme Court. Okay, next. C, the Union Minister in charge of law and justice as a member ex officio. So Union Law Minister is also ex officio member as per this act, which Supreme Court declared unconstitutional in this case. D, so 4 members are there, 3 Supreme Court judges, Chief Justice of India, and 2 more judges as per seniority. 2 eminent persons to be nominated as a member. So Law Minister 4th, then 2 eminent person again. So 3 judiciary and 3 non-judiciary, like this. Constitution 99 Amendment Act 2014, validity held by the Apex Court. It is unconstitutional and void. So this is the effect of this case. To achieve the purported objective, Article 124 and 217 inter alia amended, and Article 124A, 124B, and 124C inserted in the Constitution through the Constitution 99 Amendment Act by following is the procedure contemplated. So now we are moving towards case number 37. Union of India versus Sriharan, Murugan and others, December 2, 2015. This is a case which is very famous. This is criminal case, remission of sentence. Tamil Nadu government, Rajiv Gandhi assassination case. A 5 judges bench, Constitutional bench decided. Criminal remission of sentence, present petition filed for quashing the letter issued by the government of Tamil Nadu, wherein state of Tamil Nadu proposes to remit sentence of life imprisonment and to release respondents who were convicted in Rajiv Gandhi assassination case in pursuance of the commutation of the death sentence. Whether exercise of power of remission under section 432 of Code by state of Tamil Nadu in case of respondent was impermissible. It is held by Apex Court. Petitioner relied on Swami Shraddhananda versus State of Karnataka to state that the life imprisonment imposed on commutation of death penalty will mean till end of the life, and thus beyond exercise of power of remission. Therefore, petitioner contended that exercise of power of remission under section 432 of the Code by state of Tamil Nadu in case of respondent was impermissible. It was not appropriate for 3 judges bench to examine and decide correctness of the verdict of another 3 judges bench in Swami Shraddhananda Supra. Considering wider interpretation of the provisions of the Constitution and Code involved in matter, consider it fit to refer matter to the Constitutional Bench for authoritative interpretation on the same. Matter referred to the Constitution Bench, petition disposed of. We reiterate the relevant provision section 432 and 435 of the Code. Accordingly, in this matter, we are called upon to decide the legitimacy of the proposal of the state government to release respondent number 1 to 7 who are facing life sentence for the purpose of the disposal of this issue in question. Case number 38. Gujarat Urja Vikas Nigam Limited versus Emco Limited and others, February 2, 2016. Electricity and tariff determination. This case is depend upon tariff determination of this Gujarat Urja Vikas Nigam Electricity Board. 2 judges bench case electricity, tariff determination for the procurement of power by the distribution license in Gujarat from solar energy projects. Tariff determination by order dated 29/1/2010, first tariff order taking into account the benefit of accelerated depreciation under Section 32 of the Income Tax Act and rules. The order also provided the determination of separate tariff for the project which did not get benefit of accelerated depreciation. Appellant entered into the power purchase agreement PPA and for sale and purchase of electricity with the respondent. Power produced for the project to be established by it, however, could not commence generation of power within the control period stipulated under first tariff order. Another order dated 27/1/2012, second tariff order determining the tariff applicable to the projects to the commission on or after 29/1/2012. The power produced commenced generation of the power subsequent to the second tariff order. The power produced petition to the State Commission of the permission to claim tariff as per the second tariff order allowed. Order of the State Commission confirmed by the Appellate Tribunal. Order of State Commission confirmed by Appellate Tribunal. order of State Commission conferred by Appellate Tribunal on appeal. After Appellate Tribunal, appeal comes to the Appellate Court, and on appeal held that the term of PPA does not entitle to the power produced to the tariff as determined by the second tariff order. The benefit of the accelerated promotion flow from the Income Tax Act, which was dependent on the option of the power producer. PPA does not make any reference to such benefit. The availability of the option does not relieve the power producer of the contractual obligation incurred under PPA. Therefore, the power producer is not entitled to tariff as per second tariff order. So, this case is like this. Those who are interested in corporate matter, or those who are interested in arbitration matter, they used to such type of reading this such type of cases, because these cases are very important in corporate law. Now, Nirbhaya case number 39. Mukesh. Nirbhaya case is not the cause title of that case. Cause title is Mukesh and another versus State of NCT of Delhi and others, May 2017. Criminal, capital punishment, gang rape, rarest of rare case. This is very, very sad case. This is very, very. Just a minute. Yeah. Criminal, capital punishment, gang rape, rarest of rare category, section 120B, 201, 302, 306, 365, 366, 376-2, G, 377, 395, 397, and 412 of Indian Penal Code 1860, and section 235 and 354 of the Code of Criminal Procedure 2017. Deceased prosecutor and informant boarded bus. Accused person started to abuse informant and assaulted him with iron rods, robbed their articles. Prosecutor was raped by them, one after another, one after other. Prosecutor was also subjected to unnatural sex. Her private parts and her internal organs were seriously injured. Accused were exhorting that both victims is not left alive. Threw them out of moving bus. Victims were taken to hospital. First information report was registered. First accused was arrested. Personal search was conducted and his disclosure statement. Investigating officers seized bus, arrested of first accused, led to arrest of fourth and fifth accused. Later on, second accused was apprehended. Mobile belonging to informant was recovered. The test identification parade informant identified second accused. Further recoveries were made. Dying declaration of proceeds was recorded. Prosecutrix gave her statement through gesture and writing. Later on, in foreign hospital, prosecutrix died. Charge sheet came to be filled under provision of Code 1860. Supplementarily, charge sheet was filed later on. During course of trial, first accused committed suicide. Session judge convicted all accused persons under section 120B, 365, 366, 307, 376-2 G 377, 302, 395, 397, 207, 201, and 412. 302 on 30 section 302. My book is there on Supreme Court case laws of, and 376 also, and acquittal from 376. One another judgment book is also there on online platform. This is not books are not available in any bookstore. My all books are available on online platform. You just get it directly at your home. No need to go here and there. And very reasonable price of all my books. I'm not promoting my books. Just I remember that thing, so I'm just telling you. I think you are well learned. You are well prepared also. So prepare your nicely for your examination. And after your examination, definitely read these judgments also in detail when you find the time. And a Supreme Court judgment, so in Supreme Court judgment, they have given the summary of the session court judgment. Like in session court judgment, you will find out, you can read it proper, everything. So read that judgment also in such type of cases. So all accused were sentenced to death for offense punishable of imprisonment was also avoided. Fine was also imposed. High Court upon conviction and confirmed death penalty. Trial court given death penalty. High Court also confirmed that same death penalty. Hence, present appeal by all accused appellant. Whether accused persons was guilty of their culpability and there was public pressure as alleged to the falsely implicate them. Whether court below did not follow fundamental norms of sentencing and were not guided by paramount beacons of legislative policy, discernible from section 354(3) to 35(2) of the Code 1973. So I'm reading once again this because a question can be framed on this line. Whether court below did not follow the fundamental norms of the sentencing were not guided by the paramount beacons of legislative policy like that. Whether there was violation of mandate of section 235(2) of the Code of Criminal Procedure 1973, whether present case would be one of the rarest of rare case warranting death penalty. And Supreme Court dismiss this appeal. Then review also dismiss. Then curative also. And one person's curative was pending. So a midnight hearing at that time was done. At night hearing was done, curative dismissed, and early in the morning, death sentence executed. This is the case. You can get one question also. What is the procedure of midnight hearing? That is not given anywhere. Supreme Court rules, no, nothing mentioned there. What is the procedure of midnight hearing? What is a midnight hearing? People don't know what is midnight hearing. Just I'm telling you, hearing after court hours is called late night hearing. Even though it is after 7 p.m., 8 p.m., even though it is called late night hearing. So what is the procedure of that? So this is not the question of today's subject, so I will not give the answer. But you are sufficiently talented, you can get this answer. Case number 40. Excel Corporation Care Limited. Excel Crop Care Limited versus Competition Commission of India, and another May 8, 2017. This cases specifically depend upon Competition Act 2002. Anti-competitive agreement and doctrine of proportionality and purposive interpretation is discussed here in this specific case. Two judges bench was at that time. Competition Act 2002. There is my one video on Competition Act on YouTube. Section 3, subsection 3, subclause A, 3(3)(b), 3(3)(d), read with section 3(1) and section 26(1), 27(b) of the Competition Act. Complaint by Food Corporation of India, that is called FCI, alleging that their 3 appellant companies and 1 more company had arrived at anti-competitive agreement in relation to the tender issued by FCI for aluminum phosphide tablet between the years 2007 and 2009. Competition Commission of India directed investigation. Director General, that is a DG, gave report giving prima facie finding affirming the allegation. CCI conducted that the appellant companies entered into anti-competitive agreement in concerned matter, thereby offending the provision of sections 3. Imposed penalties on all the 3 appellants at 9% of average 3 years turnover. You cannot, in this era, you cannot do the collaboration and try to collaborate and try to get monopoly like that. So for prevention of this law is into existence. Competition Act. Otherwise, suppose a Geo all cellular company will come and form the agreement from henceforth. Our richer voucher should be more than 1,000 people. So they will then grabbing us. It should not happen. To prevent this law is into existence. And on this ground, this case is very important. Competition Appellate Tribunal confirming the finding of CCI, however, reduced the penalty, holding that the penalty at 9% cannot be on the total turnover and has to restricted to 9% of the relevant turnover. On the appeal question whether section 3 was applicable in respect of the tender issued prior to coming into force of section 3, whether CCI was barred from investigating the matter pertaining to tender floated in 20 JI, as there was no complaint about that the tender, whether finding as regards collusive bidding was justified, and whether the penalty has to be on total turnover, only on the relevant turnover of the offending company. Supreme Court held section 3 would be applicable in respect of the tender issued prior to coming into force of section 3 as well, because the anti-competitive conducts of the offending companies continued even after coming into force of section 3 to 2011. Tender also could be the subject matter of the inquiry, even when it was not referred to in the complaint. Doctrine of proportionality, doctrine of purposive interpretation, and doctrine of nacitur solis. Yeah, I want to publish one book on only doctrines, meaning of doctrine, the birth of that doctrine, in which judgment like that. But when I find time, then I will definitely do. one on ratio descendants. Ratio descendants is also a good topic. Yeah. Case number 41, Common Cause versus Union of India and others, August 2, 2017. This case is depend upon mine and minerals, legal mining in Odisha state, and CBI investigation. Two judges bench, mines and minerals, illegal mining of aromas proportions in districts of Odisha. Writ petition partly based on the reports given by the Justice M.B. Shah Commission of Inquiry South Direction inter alia to Union of India and Government of Odisha to immediately stop forthwith all illegal minings in the state of Odisha and for CBI investigation into such illegal mining. Plea of mining lease holder that reports given by the commission were vitiated as they were not given notice under section 8B, 8C of the 1952 Act. And thus the very foundation of the writ petition goes away. Held, first report given by commission was general. Overall perspective on the subject, no irregularity or illegality has been committed so as to vitiate the first report. Second report went into specific details of the several mining leaseholders, but herein one is not concerned with those specified. Therefore, whether notices were issued or not to the leaseholders who were subject matter of discussion in the second report is of no consequence. However, the report of the commission are not being relied upon the purpose of the present judgment and order. In this case, Central Empowerment Committee is also discussed. Mineral Concession Rule 1960, also MCR discussed. Mineral Conservation and Development Rules 1988, MCDR is also discussed. Environment Protection Act 1986, also properly section 3132V, Environment Protection Rules 1986. These are also discussed. On any this question can come. Yes, and you have to write. But if you don't remember in which case laws this matter is, then what is the use of that case notebook there at the time of examination? So for understanding it properly, you should know the basic idea, basic need of that, basic outcome of that particular case, on which theme that case is. Now, case number 42. Saira Banu versus Union of India. This is triple talaq case. Muslim law. Talaq-e-biddat. Set aside. Talaq is set aside. So from that day onwards, giving triple talaq is offense. High judges bench decided this. Majority opinion 3:2. 3 have set aside and the against it, but not totally against, but they have some different view. So question can become on minority views also, or majority views also, or general question can be. Muslim law, talaq-e-biddat, the practice of talaq-e-biddat is set aside. Muslim law, talaq-e-biddat, triple talaq by Muslim husband, which severs the marital bond. Constitutionally, it is held by Apex Court. In Shamim Ara case, it was held that the correct law of talaq, as ordained by the Holy Quran is that the talaq must be for reasonable cause and preceded by attempt at reconciliation between the husband and the wife by two arbiters. There should be two arbiters. They should try to reconcile. So this is the procedure of the talaq. But only talaq, ho gaya talaq. No, this is not acceptable. One from the wife's family and other from the husband's. If the attempt fail, reconciliation, compromise, attempt if fail, talaq may be affected. Given the fact that triple talaq is instantaneous and irrevocable, it is obvious that any attempt at reconciliation between the husband and wife by two arbiters from their families, which is essential to save the marital tie, cannot ever take place. This form of talaq is manifestly arbitrary, in the sense that the marital tie can be broken conspiracially and whimsically by Muslim man without any attempt at reconciliation so as to save it. This form of talaq must therefore be held to be violative of fundamental right contained under Article 14 of the Constitution of India. Therefore, the 1937 Act, insofar as it seeks to recognize and enforce triple talaq, is within the meaning of the expression law in force in Article 13(1) of the Constitution of India, and must be struck down as being void to the extent that it recognizes and enforced triple talaq. कुछ डिसीजन से क्रांतिकारी रहते हैं दोस्तों, क्रांति कर देते हैं. मुस्लिम वुमन बहुत दुआ दी होगी ये जजमेंट के ऊपर, बहुत अनसिक्योर्ड महसूस करती थी. कब हस्बैंड को गुस्सा आएगा, कब वो तलाक कर देगा, कब रिश्ता हो जाएगा. इट इज सो इजी. आई एम नॉट अगेंस्ट एनी रिलीजन. आई एम इंडियन. आई एम पैट्रियोटिक पर्सन. I respect all religions. I respect Quran. I respect Bible. I respect Bhagavad Gita. I respect all the Granths. But bad is bad. So this judgment was like that. Now, case number 43. Justice K.S. Puttaswamy, retired, and another versus Union of India and others, August 24, 2017. This case is depend upon Article 21, right of privacy. Aadhaar card. Two cases, you will find two cases similar in these 64 leading cases. Both are literally same Aadhaar, but this case is little bit different to each other. So this is the first Aadhaar case, another Aadhaar case. I will read when its sequence comes. So 9 judges bench was there. And before arguing constitutional bench, before arguing more than 3 judges bench, is very hard, because any judge can ask any questions to you. What is the preparation of your sequence in mind? It gets disturbed. But you have to keep calm, quiet before arguing such type of bigger bench. So highest bench was 13 judges bench, Keshwanand Bharati case. And this particular case was Justice Puttaswamy, Aadhaar case 2017 case, 9 judges bench. Constitution of India, Article 21, right to privacy. Privacy is a constitutionally protected right in India. The decision in MP Sharma, which holds that right to privacy is not protected by the Constitution stands overruled. The decision in Kadaksi, to the extent that it stands overruled. The decision in Kadaksi, to the extent that it holds that the right to privacy is not protected by the Constitution stand overruled. Right to privacy is protected as an instinct part of the right of life and personal liberty under Article 21 and as a part of freedom guaranteed by Part 3 of the Constitution. Constitution in India, Bare Act is very small, but when you read the commentaries, so very big commentary, when you read the commentaries, now, that time you can understand. Commentaries are very useful for arguments. So here the 3 volumes. Constitution of India, Volume 1, Volume 2, Volume 3. This is CPC. CPC Volume 1, CPC Volume 2, CPC Volume 3, CPC Volume 4. These are very important for argument people. It is available on libraries. You can use the libraries, you can bar libraries, but never don't depend upon only bare acts. Specifically in highest court practice, upper court practice. Trial court practice, tehsil court practice can be managed through bare act. But when you are arguing before High Court and Supreme Court, you should have the touch of the commentaries now. Evidence Act, see in my library, Evidence Act. 5 volumes are there. Law of evidence. Law of evidence is a very important law. So, friend, now see this case. I just want to inspire you for more study, to get more interest in argument of the High Court and Supreme Court like that. Constitution of India, Right to privacy is protected as the instinct part of the right to life and personal liberty under Article 21 as the part of the freedom guaranteed by the Part 3 of the Constitution. Aadhaar. Targeted delivery of financial and other subsidies, Benefit and Services Act 2016. As per the court, the Constitution is sacred, living document and hence acceptable to appropriate interpretation of its provision based on changing need of the society. It is held the decision in MP Sharma, which hold that the right to privacy is not protected by the Constitution, stand overruled. If right of privacy is not protected, it stands overruled as per the Constitution of India. The decision in Khadak Singh, to the extent that it holds that the right to privacy is not protected by the Constitution, stand overruled. So Khadak Singh also decision of particularly privacy is also overruled, earlier also overruled. And third, the right to privacy is protected as the instinct part of the right to life and personal liberty under Article 21 and a part of the freedom guaranteed by Part 3 of the Constitution. For decisions subsequent to Khadak Singh which have initiated the position in 3 above laid down the correct position in law. Case number 44. Common cause, the registered society. This is second case of common cause registered society versus Union of India and another. Cost title is same, but year is different. March 9, 2018, and outcome is different. Outcome of this case is right to self-determination, Article 21, right to die with dignity. When person is mentally dead, totally dead, there is no chance to recover that time. right to die with dignity, whether it is constitutional or not. This matter is discussed in this case. And apex court accepted this right, but with some specific conditions. That conditions should follow like that. So I am giving you some glimpse. Constitution, right to self-determination, Article 21 of the Constitution of India. Present petition filed seeking declaration that the right to die with dignity be declared fundamental right within the right to live with dignity under Article 21 of the Constitution. Whether person be allowed to remain in stage of incurable, possibly suffering, or treating utterance of the death as a rhetoric, whether law permits accelerating process of dying, science suffering when life is on inevitable decay, whether right to life under Article 21 of the Constitution include right to die, held by the apex court. In view of our conclusions, as noted above, the writ petition is allowed in the following manner. The right to die with dignity as a fundamental right has already been declared by the Constitution Bench judgment of this court in Gyan Kaur case supra, which we reiterate. Reiterate means again we are telling that. We are again and again reiterate. We declare that an adult man, adult human being having mental capacity to take an informed decision has right to refuse medical treatment, including withdrawal from life-saving devices. And C, a person of the competent mental faculty is entitled to execute an advance medical directive in accordance with safeguard as referred to above. Now, case number 45. Municipal Corporation Ujjain and others versus BVG India Limited and others, March 27, 2018. This case is dependent upon tender. Solid waste collection contract. Solid waste collection early in the morning, MCD people are coming, collecting the waste. So tender, regarding the tender of collecting the waste. So this is contract. 3 judges benches there. Tender. Appellant corporation issued NIT for appointment of agency to carry out municipal solid waste door-to-door collection and transportation. Bids were invited following 2 envelope systems, that is technical bid and financial. Technical bid of the parties were analyzed throughoutly by the technical experts and marks were awarded as per the specification of NIT. Global Waste Management Center Private Limited scored highest mark based on the technical and financial vested scores and hence was awarded the contract. Aggrieved the unsuccessful bidder, respondent number 1 filed writ petition in High Court. High Court allowed the same and sent aside the contract awarded in favor of GWMC. In appeal, when it comes to our apex court, as a decision was qualitatively arrived at by the technical expert, respondent number 2, the High Court need not have gone into the merit of such a decision as an appellate authority especially when there was no bias or malafide. There was no illegality, arbitrariness, irrationality, and unreasonableness on the part of the expert body while in action. Moreover, the decision was taken keeping in mind the public interest and work experience of the successful bidder. In absence of any document evidencing the experience in the field is questioned in favor of respondent number 1. The High Court was not right to increasing the marks under the head of the number of years of experience and expertise. Now, case number 46. Shakti Vahini versus Union of India and others, March 27, 2018. This case depends upon the honor killing, are condemned as a serious human right violation. Article 19 and 21. 3 judges bench. To love marriage happens, two different caste people, couples are marrying each other, and in rural area, in some part of our country, honor killings happens. हमारा नाक कटवा दिया ये वो, and they are killing people. Such type of things are happening nowadays. Lower caste, upper class, all has gone. Only educated class, uneducated class, upper educated class, this class system is now there. So when there are two MBAs, when they are marrying, so we can treat them in one class. But that caste system, older days class system, even though that is in the mind of the people, to wash out the such type of bad things, the judgment is very good. Writ petition, seeking direction to the state government and central government to take preventive steps to combat honor crimes. To submit the state and national plan of the action of curb such crimes, and seeking direction to the state government to constitute special cells and to launch prosecution in such cases. It is held by our apex court. Any kind of torture or torment or ill treatment in the name of honor that tantamount to atrophy of choice of an individual relating to love and marriage by any assembly. Whatsoever nomis culture is assumed is illegal and cannot be allowed. Consent of the family or the community or the clan is not necessary when two adult individual agrees to enter into wedlock. It is manifestation of their choice which is recognized under Article 19 and Article 21 of the Constitution. Such constitutional right cannot succumb to the conception of the class honor. Any infringement of such right is constitutional violation. Khap Panchayat and such assembly should not take the law into their hand and further cannot assume the character of the law implementing agencies. Law has to be followed to sustain by the law enforcement agencies. Honor killing are condemned as a serious human right violation. Now, case number 47. Navjit Singh Johar and others versus Union of India, their secretary, Ministry of Law and Justice, September 6, 2018 case. Right of sexuality, free consent, adult, LGBT allowed. Section 377 of IPC, 5 judges bench. Very interesting case. Constitution, validity of provision, section 377 of the Indian Penal Code, 1860, that is IPC, and Article 14, 15, 19, 21 of the Constitution of India. Writ petition was filed for declaring the right of sexuality, right to sexual autonomy, and right to choose a sexual partner. This is very krantikari judgment. To be the part of the right to life guaranteed under Article 21 of the Constitution of India, and further to declare Section 377 of IPC to be unconstitutional. Whether Section 377 of IPC, as it criminalizes consensual sexual act of adult, that is a person above the age of 18 years who were competent to consent in private, was violative of Article 14, 15, 19, and 21 of the Constitution. Individuals belonging to LGBT group suffer discrimination and abuse throughout their lives due to the existence of this section 377 of IPC, which is nothing but manifestation of mindset of social values prevalent during the Victoria era. Held by Apex Court in this matter, in this petition. In view of the aforesaid finding, it is declared that insofar as Section 377 criminalizes consensual sexual act as adult is in private, is violative of Article 14, 15, 19, 21 of the Constitution. So that section is unconstitutional. It is, however, clarified that such consent must be free consent, which is completely voluntary in nature and devoid of any grace or coercion. Jabardasti, no. It should be a free consent. The declaration of the aforesaid reading down of the section 377 shall not, however, leading to the reopening of any concluded prosecutions, but can certainly be relied upon in all the pending matter, whether they are at the trial, appellate, or revisional stages. The provision of section 377 will continue to govern. Section will continue to govern non-consensual sexual act against adult, all act of carnal intercourse against minors, and act of bestiality. So this is the very effective judgment. And last case, leading case of session 3 of our program is case number 48, Justice Jayprakash Somani, retired, other second case, and versus Union of India and others, September 26, 2018. Aadhaar scheme, right to privacy, Article 14, 19, 21, and 110. That is 110 article, etc. 5 judges bench. Constitution. Aadhaar scheme, right to privacy, Article 14, 19, 21, 110, and 1101 of the Constitution of India, and Section 7, 28, 5, 29, 29.1, 29.2, 33, 47, 57, 59 of the Aadhaar Act 2016. Present petition filed challenging constitutional validity of Aadhaar Act 2016 and exclusive executives scheme notified by the government by which Unique Identification Authority of India UIDAI was constituted to implement the UIDAI scheme. In writ petition scheme had preliminarily been challenged on the ground that it violates fundamental right of innumerable citizens of India, namely the right of privacy following under Article 21 of the Constitution of India. Whether provision of Aadhaar Act 2016 was liable to struck down as violative of Constitution held by Apex Court while disposing of the appeal, not dismissing, disposing of the appeal. There is a difference between dismiss, disposal, withdrawn, like that. We have noticed above that according to Aadhaar Act Section 33, disclosure of information can be made as per the Section 1 pursuant to an order of the court, not inferior to that of the district judge. The order directing to disclosure of information having been passed by the judicial magistrate first class in the present case. The order is not the consonance with the subsection 1 of Section 33. Hence, the order passed by judicial magistrate first class dated 21/10/2013 and order of the High Court passed in reference to the said order deserves to set aside. Criminal appeal is allowed accordingly. Sometimes judges are very appreciating to the lawyers also. Let me read one line of this Uttaswamy judgment. A good remark for lawyers also. Before we part, we record our deep appreciation for the industry, hard work, and eloquence shown by learned counsel for the parties appearing before us, which was amply demonstrated in their respective arguments. Learned counsel have enlightened us with all relevant concerned materials available in this country and abroad. Or some more lines are also there. So, friends, this is the end of our session 3. And they start 9 people was, I think 7 was there, including myself, 7 or 9 something. Now 12 are there. So this is good scenario. Let's see in session 4. I will start session 4 after 10 minutes. Take 10 minutes gap. Just let me tell you the time. 19:25 is now. So we will start it 19:35. Thank you.